Good afternoon, everyone, and thank you for attending this virtual talk. Today, I'm going to speak about the different federal programs for radiation exposure compensation in Russian Federation and the United States. So before I do that, let me share my PowerPoint presentation with you. These programs that I'm going to talk about were enacted for people living in these countries who were exposed to radiation from atmospheric nuclear testing from the years of 1945 in the United States, 1949 in the Soviet Union, to 1963. During this period, the Soviets tested 219 nuclear devices in the atmosphere, the majority of which occurred at the Semipalatinsk nuclear test site in Kazakhstan and Novaya Zemlya in Russia's Arctic region. The United States, by close comparison in number, conducted 215 atmospheric tests at its Nevada test site, but also at military proving grounds in the Marshall Islands in the South Pacific Ocean. In 1963, a global moratorium, the Limited Test Ban Treaty, halted all testing in the atmosphere, underwater, and outer space. Regarding both the United States and the Soviet Union, there was and has been a significant time lag between radiation exposure from atmospheric tests and the implementation of programs that sought to provide social benefits to people whose health and environment were damaged as a result. The laws governing radiation exposure compensation in both states are legally complex, and speaking to Russia in particular, they have frequently been amended and are not available in a common archive. A common point of reference for both, however, is that benefits are difficult to obtain. I am dividing the following presentation by country, and will start with the Russian Federation before I continue on to speaking about the United States. As a preamble to both segments, where helpful, I talk briefly about the origins of public nuclear concern, and with Russia, the story begins with Chernobyl. So let me begin with this. The Soviet Union has a strong symbolic connection with nuclear accidents in world history. The 1986 disaster at Chernobyl reactor facility in Ukraine had important implications for how the Russian Federation addressed the questions of environmental contamination, as well as human health effects of persons exposed to Soviet-era atmospheric tests. Prior to 1986, there were environmental laws in place in the Soviet Union, but they were mostly declarative and not effectively enforced. One such example was the law of October 27, 1960 on the protection of nature in the RSFSR. This referred specifically to the protection of natural resources such as lands and forests. Meanwhile, it was bylaws that addressed issues of nuclear security and energy sector in which Chernobyl belonged. For example, the Radiation Safety Standards, NRB 76, and the General Sanitary Rules of Work with Radioactive Substances and Other Sources of Ionizing Radiation, OSB 72-80, set out annual limits for radiation dose for workers. Besides this, the Soviet Union did not adopt any general laws regarding compensation for radiation exposure and benefits when it comes to atmospheric tests. And benefits, if there were, included payments to war veterans, disabled persons, and pregnant women. It was only after Chernobyl and the subsequent collapse of the Soviet Union in 1991 that any meaningful work on social legislation aimed at compensation for health damage to those affected by this and other incidents of radiation exposure and provisions for additional medical and other benefits actually occurred. Not all of them deal with nuclear testing specifically. These programs provide social support for specific categories of citizens exposed to radiation related to three events. First, the Chernobyl disaster. Second, the Mayak production facility accident and dumping of radioactive waste in the river Techa. And three, finally, exposure to atmospheric radiation fallout at the Semipalatinsk nuclear test site. I want to focus briefly on the first two as a point of comparison before moving to the last example, only because it's from these compensation programs that a compensation program for victims of atmospheric testing actually emerged. All of these programs that I'm going to talk about are quite complex and difficult to navigate. But suffice it to say that all make some form of payments directly to all of the citizens that fit very specific guidelines in them. So let me take each one in turn. One of the first laws passed by the Russian Federation was on May 15th, 1991, law number 1244-1, titled On Social Protections of Citizens Exposed to Radiation as a Result of the Chernobyl Disaster. This program was amended countless times, with the last amendment done in 2020. Nearly 9.2 billion rubles have been allocated to the implementation of this program to address health, environmental, and social issues due to the accident. I will summarize this briefly. Citizens of the Russian Federation are guaranteed compensation for living and working in the territory exposed to radioactive contamination exceeding permissible levels. These territories, there are 4 territories that are specifically addressed. The first one is the exclusion zone, likely familiar to many, an area that's 30 kilometers around the Chernobyl nuclear plant. 2, the resettlement zone, which is just right outside of the exclusion zone, but has soil contamination, is contaminated with cesium-137 and produces an average annual effective equivalent dose to the population of over 5 half a rem. Zone of residence, the third one is zone of residence with right to resettlement, which is outside of both the exclusion and the resettlement zone, where the annual effective equivalent dose to population exceeds 0.1 rem. And then the fourth one is the zone of residence with preferential socioeconomic status, which is outside of the 3 zones and where an average annual effective equivalent exposure dose does not exceed 0.1 rem. The boundaries of these zones and a list of settlements located in them are established depending on changes in radiation survey every 5 years. Today, and depending on their disability class, around 702,000 people have been registered in the National Register as victims of Chernobyl accident, majority of which are located in the Bryansk region, 44.2%. Category 1 disabled people receive, for example, a one-time payment of 32,000 rubles, Category 2, 22,000 rubles, and Category 3, 16,000 rubles. And all of those of the above categories require extensive documentation of residence and establishment of disability based on total accumulated radiation dose, with the exception of liquidators, people who actually participated in the cleanup of the Chernobyl zone, people who worked from 1986 and 1987, as well as those who worked on building the sarcophagus, the security structure that goes over the Chernobyl, the damaged reactor, who worked on it from 1988 to 1990. Depending on the disability category, people may be entitled to subsidies for utilities, housing, early retirement, and access to additional medical help. The Chernobyl Compensation Program followed a broad enactment of the December 19th, 1991 law on the protection of the natural environment that declares the country's commitment to environmental protection. Subsequently, environmental human rights, including the right to receive environmental information, were enshrined in the Article 42 of the Constitution in 1993, and later Article 11 of the Federal Law of January 10th, 2002 on environmental protection, which made the right to environmental information become part of the legal field of Russia. And the establishment of these environmental human rights led essentially to laws on compensation for Mayak victims, as well as those affected by atmospheric tests at the Semipalatinsk nuclear test site in Kazakhstan. The next important piece of the history of the Russian Federation's program for nuclear compensations goes retroactively back to the early years of the Cold War and to an event at a facility called Mayak near Yekaterinburg. This was the first Soviet nuclear complex to manufacture plutonium for military purposes. On September 29th, 1957, an explosion occurred, caused extreme levels of contamination. It was labeled 6 on the International Nuclear and Radiological Event Scale. Chernobyl and Fukushima are both 7. This federal law titled On Social Protections of Citizens of the Russian Federation Exposed to Radiation as a Result of the Accident in 1957, that was created on November 26, 1998, applies to citizens who have received or have had radiation sickness, other diseases included in the list of diseases, such as leukemia and thyroid cancer, for example, or who have become disabled as a result of exposure to radiation. The broad group of potential compensation recipients includes participants in the liquidation of the catastrophe who worked between specific dates, September 29th, 1957 and December 31st, 1961, and those doing cleanup on the Techa River from January 1st, 1949 to December 31st, 1962. The second group includes citizens who were evacuated. And the third group includes citizens who lived in adjacent settlements between 1949 and 1956 that were exposed to radioactive contamination as a result of radioactive discharges into the Techa River, and who received an accumulated effective radiation dose of over 35 millisieverts. The categories of people also who could claim benefits included those who voluntarily resettled after the 1957 accident and families who lost a breadwinner because of the accident in Mayak. Regardless, any of the above groups required extensive documentation confirming one's involvement in work, as well as attestations confirming the fact and duration of residence in the settlements listed, documents providing the value of the accumulated effective dose, and proof that the breadwinner died, worked, or lived there, or is part of the family. A broad stroke survey of the benefits include housing help, 50% payment for utilities, annual paid vacation for the duration of 14 days, medical costs for children, monthly compensation for the purchase of food, annual compensation for the improvement of health. Citizens who voluntarily left get an additional annual compensation for health improvement, but also a one-time allowance in connection to moving to a new place. It may seem a detour to discuss Chernobyl and Mayak incidents, as these were not nuclear testing events, but they have served as a frame of reference for understanding the Russian Federation's approach to citizens affected by nuclear testing. Turning attention to question of atmospheric nuclear tests, the legislation begins with the federal law of January 10th, 2002, that specifically guarantees social protections to people exposed as a result of testing at Semipalatinsk. Semipalatinsk, as I mentioned earlier, was the primary proving grounds for the Soviet Union, and while there are others, compensation only exists for activity carried out on this site. The language used in the federal law does not label people who are affected by radiation fallout as victims, but rather only as citizens. The legislation of 2002 goes back to February 10th, 1995, where there was an order of the government of the Russian Federation, order number N162G, as well as an order of 356G that lists specific settlements, both in the Altai region of the country of Russian Federation, and we can see Altai Krai right here. This is the Altai region of the Russian Federation. So actually, I'm going to bring it back to this map. It's northeast of Kurchatov and north of the city of Semyey. So rather than providing a list of affected settlements throughout the period of atmospheric nuclear testing between, let's say, 1949 and 1963, these orders provided a list of settlements affected by only two tests. One on August 28, 1949, which was the first test that the Soviet Union ever conducted, and the other August 7, 1962. As with Chernobyl and Mayak, legislation, the listed settlements related to Semipalatinsk were divided into categories dependent on the total accumulated effective radiation dose due to either external or internal radiation. So there were two groups, people who were in settlements at the time of the two tests who received between 5 to 25 rem, and those in these settlements, whether in Kazakhstan or the Altai region, who received more than 25 rem during the tests. And actually, this map here shows some of the tests, some of the fallout patterns from the test site. The geography of the settlements was selective and included places in the Russian Federation as well as Kazakhstan. So in Russia's Altai region, there were 11 districts that include roughly 150 towns that received between 5 and 25, as Russians refer to it, centisieverts, and were linked to those two tests. And less than 50 towns who were counted as exceeding 25 centisieverts, 25 rem. As for Kazakhstan, the list included two regions, both Pavlodar and Semipalatinsk, and roughly 60 towns, majority of which did not exceed 25 rem when it comes to exposure. And people who lived in these settlements during these two tests were entitled to food subsidies and extra medical care, depending on their category of disability. The 2002 law, which was amended numerous times, most recently on April 24th, 2020, recognized that there is a group of people affected by atmospheric Soviet tests from the entire period of 1949 and 1963. Who did it recognize specifically? Still the same people from the settlement lists. Just as the others were divided into two groups, ones who received a certain amount, then another group of radiation, they received benefits accordingly, that included food subsidies, including for children under the age of 18 of the first and second generation of these citizens who were suffering from diseases due to radiation exposure. Those seeking benefits have to prove their place of residence at the time of atmospheric testing, as well as the total effective dose due to external and internal irradiation. To even calculate this sort of dose, a lot of things are taken into account, including the characteristics of radiation exposure during a specific nuclear test, and only people from the list of towns established earlier in 1995 were able to even ask for compensation. So sometimes there will be a town included in the list, but 1 kilometer or so next town over was not included in the list. Interestingly, unlike with Chernobyl and Mayak, radiation certificates were given or continue to be given out by the Ministry of the Russian Federation for Civil Defense, Emergencies, and Elimination of the Consequences of Natural Disasters, or EMERCOM, not regional doctors. And people oftentimes complain that EMERCOM's testing simply minimizes their dose. There was, moreover, a problem with the 2002 law. The regulatory documents of the Russian Federation on Semipalatinsk test site contradicted the constitution of the Russian Federation. The federal law of 2002, for example, covers all the tests from 1949 to 1963. However, the orders of the government of the Russian Federation implementing this law list only 2 explosions, the first one and the one from 1962. As a result, people seeking benefits had difficulties getting them. And it was only in 2010 that the law was amended. However, when it was amended in 2010, it only now provides monthly compensation of 646 rubles for the purchase of food only to those citizens who received a dose of 25 centisieverts and higher, as well as compensation for school meals for the first and second generation of children of those exposed, 92 rubles per month for school-age children, for example, and 476 rubles per month for preschoolers. Moreover, the cities of Semipalatinsk, Ust-Kamenogorsk, and Ohrid, all of those cities that are located in the vicinity of the test site, were never on the list of settlements. So if people actually lived in these cities during testing, where the cloud actually did go over that area, they are not eligible to receive benefits. Let me now turn to radiation compensation programs in the United States. Legislation to address the health impacts of radiation exposure on workers and communities in the United States that dates back to the 1970s. The story really begins in 1979 with Orville Kelly, a US Army commander of Japtan Islands in the Pacific, who witnessed 22 detonations of nuclear weapons. Kelly organized the National Association of Atomic Veterans, or NAV. The mission statement of NAV was for the US atomic veteran community to speak with a single voice to their inability to get a fair hearing related to the developing radiogenic health issues. Atomic veterans, as per the NAV, are members of the United States Armed Forces who participated in atmospheric and underwater nuclear tests from July 16, 1945 to October 30th, 1962. But the group also includes those who were part of post-test duties, including those who decontaminated ships and field equipment, those who recovered test instruments, as well as those who worked in close proximity to radiated test animals. Within NAV, a second group of atomic veterans was defined as those individuals whose duties involved labor on underground nuclear experiments after 1963. Who regularly came in contact with radiation-producing equipment, such as X-ray technicians, or were assigned to the radiation cleanup projects on the Enewetak Atoll in the US Pacific Proving Grounds. The association estimates that at least 200,000 US troops participated in atomic tests and cleanup. Out of that group, an estimated 10,000 members are alive today. In the 1970s, some atomic veterans traveled to Washington, D.C. and testified before Congress and sought help from the Veterans Administration, or the VA, to pay for medical treatments they believed were related to radiation exposure. The VA, however, summarily deemed their claims ineligible for disability and medical benefits for two key reasons. First, the Department of Defense calculated that the radiation exposure was simply too low to cause any health problems. The veterans were also blocked on a second front because injuries were incurred during peacetime, and because they were incurred during peacetime, they were not eligible for government medical benefits. In 1979, the VA did acquiesce a little bit. They designated several types of cancers, such as leukemia, that could be used to base benefits for radiation exposure, as long as the cancer diagnosis occurred 1 year after discharge. Only nearly 10 years later, in 1988, the Congress passed the first compensation bill. This bill allowed atomic veterans to access medical and disability benefits regardless of when they served, peacetime or wartime, and extended cancer diagnosis to 40 years after official military discharge. Eligible cancers were expanded to include leukemia, thyroid, breast, pharynx, esophagus, stomach, small intestine, pancreas, melanoma, lymphoma, bile ducts, gallbladder, and liver cancers. However, and importantly, several cancers were excluded, such as skin cancer, lung cancer, cancer of the colon, all cancers that importantly are among the most commonly diagnosed among atomic veterans. Outside of veterans' affairs and their benefits, a second epoch in the US radiation compensation occurred when the Marshall Islands gained independence from the United States in 1986. Turning to the plight of the Marshallese in that year, the US government provided a one-time monetary settlement for all the damages to environment and health incurred during testing program that destroyed their islands communities from 1946 to 1958. A trust fund was set up in the amount of $150 million for those affected, and a portion of the money was used to establish the Nuclear Claims Tribunal. This fund awarded monetary compensation for radiation exposure-related illnesses and environmental damage. More than $2 billion was distributed, far exceeding the settlement amount. Payments from the tribunal ceased in 2009, the point at which all of the money had been dispersed. Further requests for more compensation after this point have been denied. It was not until October 5th, 1990, that the Radiation Exposure Compensation Act, or RECA, established a federal level program to adjudicate monetary claims related to injuries due to exposure to radiation from atmospheric nuclear testing, as well as the wider uranium industry, including mining, enrichment, storage, and disposal. RECA was a direct response to lawsuits against the US government. As it turned out, many of these lawsuits were dismissed by appellate courts, but Congress passed the Radiation Exposure Compensation Act as an expeditious, low-cost alternative to litigation. The act became the only program that compensated individuals who developed serious illnesses after exposure to radiation released during atmospheric tests or during employment in uranium industry. On July 10th, 2000, because of pressures of the Act's scope of coverage was broadened to include additional groups, including uranium mill workers and uranium ore transporters, as well as to include additional geographic areas, as well as changing and adding a number of compensable diseases. Currently, the Act covers 3 groups: uranium miners, millers, and ore transporters. Second, on-site participants, and third, downwinders, or those people who've lived in proximity to nuclear test sites. However, expansion to include post-1971 uranium work, which was largely for commercial rather than governmental purposes, was not supported by congressionally mandated National Research Council report on atomic test fallout. In essence, there was no way that the US government, based on, and I'll talk about this shortly, to extend compensation past 1971 for uranium workers. So let me describe each group in turn. First, uranium miners who worked in covered uranium mines, millers and ore transporters working in the US states in specified regions of Washington, Oregon, Idaho, Wyoming, North Dakota, South Dakota, Utah, Colorado, Arizona, New Mexico, and Texas, are entitled to a one lump sum compensation of $100,000. They are covered for work from January 1st, 1942 to December 31st, 1971. For compensation, they must have worked in a covered uranium mine over the course of at least 1 year, or have been exposed to 40 or more working months of radiation while employed at a uranium mine. Alternatively, an employee may have worked in a covered uranium mill or in the transport of uranium or vanadium uranium ore from a mine to a mill for at least 1 year during the period of 1945 to 1971. In all of these cases, claimants must establish both that their uranium industry employment meets the statutory requirements and subsequent diagnosis of specified compensable diseases. And right here, here's a list of acceptable diseases that uranium miners and workers can have. Second, on-site, participants on-site in a test involving atmospheric detonation of a nuclear device are entitled to a one-time lump sum compensation of up to $75,000. On-site refers to duty above or within the Pacific test site, the Nevada test site, the South Atlantic test site, the Trinity test site, any designated locations with Naval Shipyard, Air Force Base, or other official government installation where ships, aircraft, or other equipment used in atmospheric nuclear detonation were decontaminated. On-site also includes any designated location used for the purpose of monitoring fallout from an atmospheric nuclear test conducted at the Nevada test site, but only for those tests prior to January 1st, 1963. To move forward in this process, claimants must establish both participation on site in a test involving atmospheric detonation and a subsequent diagnosis of a specified compensable disease. And we can see the diseases here on this PowerPoint slide. The third category established under the expanded Act framework was created for downwinders. Downwinders is likely one of the more familiar sounding categories of nuclear victims of the Cold War. Because of their physical presence in certain counties located downwinds from Nevada test site in the states of Utah, Nevada, and Arizona, and within those states, very specific counties, they are entitled to a one-time lump sum payment of $50,000. The claimant must establish their physical presence in the downwinder area for at least 2 years during the period beginning on January 21st, 1951 and ending on October 31st, 1958, or for the entire period beginning on June 30th, 1962 and ending on July 31st, 1962. As with other categories recognized under the Act, claimants must establish a subsequent diagnosis of a specified disease. There are many exclusions to the downwinders category. Downwinder is only applicable to designated counties, as I mentioned, and specific areas of the states of Arizona, Nevada, and Utah. And I'll go back to this map here, and we can see the downwind counties here in a dark green and the blue, for example. Interestingly, you know, some areas that are much closer to the Nevada test site, which is right here in Nevada, it has a black dot, or the Trinity site, which is located in New Mexico, the state of New Mexico, in the center of the state, roughly. While they are technically downwind in every sense, they are not eligible to receive any sort of compensation. To the Act's credit, the original map of downwinder eligibility covered smaller area than what is currently covered by the program. There are many problems with the Act. Despite expanding the scope of coverage and compensation based on geography, the National Research Council concluded that any decisions on additional eligibility for downwinders should not be made solely on the basis of geographic area. The National Research Council instituted an approach that recommended what they describe as a science-based eligibility determination process that includes several variables, not only where people lived, but the amount of time they spent outdoors and even their milk consumption. The National Research Council also uses a probability model of causation to evaluate individual claims for benefits. Individual absorbed doses, for example, would be estimated. And this has resulted, what many argue, and people who are trying to access these claims also argue, resulted in fewer successful claims. And in fact, the National Research Council argues that, you know, obviously there are fewer cases because radiation wasn't so dangerous. And actually, it's not an especially potent cancer-causing agent. And that's actually a quote. Congressman, in most recent years, Congressman Ben Ray Lujan of New Mexico introduced legislation to expand compensation for individuals exposed to radiation who are working in and living near uranium mines or downwind from nuclear testing. The goal of this legislation is to extend the Act until 1945 because it is about to sunset in 2022. So there's a very short window left for people to make any kind of claims. Today, the Radiation Act is administered by the Civil Division of the Department of Justice. To date, the Department of Justice has approved more than 36,000 claims for more than $2.3 billion in benefits. The majority of the claims are related to atomic weapons testing rather than uranium industry. As amended in 2000, the compensation process states that all of the Act's benefits applications must be filed before July 10th, 2022, before the Act is finished, before it expires. Benefits, and this is an important point, are not subject to federal income tax, but they are offset by the following things: any payments received from other lawsuits or settlements, any disability compensation or dependency and indemnity compensation payments from the Department of Veteran Affairs, for any illnesses or injuries due to exposure of radiation from atomic weapons tests or work in the radiation industry covered by the Act. There are, however, in addition to this, survivor benefits, a one-time payment to the spouse, children, parents, grandchildren, and grandparents. One, of course, has to prove the relationships and so on and so forth in order to obtain these benefits. And a lot of people are rejected and cannot obtain benefits because they don't have the documentation to prove, for example, that they worked at a particular place at a particular time, how long they were there. Native American communities, especially the Navajos or the Diné, for example, don't use customary law to get married, not the obtain standard certificates than many other US citizens do. Let me now conclude. The United States and the Russian Federation both have legacy issues when it comes to the human fallout of nuclear testing. And both countries have put up barriers to compensation with regard to geography. But putting together a concise timeline is a difficult and confusing task. Shortly after the breakup of the Soviet Union, the Russian Federation had a brief moment in which the federal government sought to pay out support and compensation for virtually any and all military or civilian personnel who were affected by radiation exposure. This was the Decree of Government of the Russian Federation from 1993, numbered N253. This law was, however, invalidated several years later and replaced with the 3 laws for Chernobyl, Mayak, and Semipalatinsk. Today, a large gap exists between Russia's formal environmental laws and social benefits to radiation victims and the state's agency's capacity to carry them out. People struggle to obtain benefits, and many choose to avoid what one applicant recently referred to as Russia's bureaucratic hell. The United States, while seemingly more transparent in its record of legislation through the Act and more accessible in terms of an archive, is no proven winner. Sociologists Susan Dawson and Gary Madsen argue that Native Americans who worked in uranium mines after 1971, who suffer from lung cancer and other diseases, should receive compensation, since safety protocols were often not followed by the industry. Federal response was not only late in both instances of the Soviet response, of the Russian response, and then the United States response, but even today, there's a significant backlog for returning applications. In the United States, the backlog is quite significant and people wait years. In Russia, the ways in which all of these laws are amended and changed every time pretty much means that people struggle to figure out what sort of documents are necessary, what rules have changed and which ones have not. I will stop here. Thank you very much. If you have any questions, you can, of course, get in touch with me via email. Again, thank you very much.